tardiness. First of all, I want to welcome all those who are attending this hearing dealing with the disciplinary process as it refers to lawyers and also to judges in the state of New York. My name is State Senator John Sampson. I'm from the 19th Senatorial District, along with my colleague, Senator John DeFrancisco, who is from Syracuse region. Am I correct, Senator? Correct. And we want to welcome you all here this morning. This is a series of hearings that will examine the disciplinary process for lawyers and judges in the state of New York. When a complaint comes to the disciplinary body, we want to know how is it being handled, how many people examine the complaint to decide what the process is, what review mechanisms are in place to ensure that once a decision is reached, it is fair and according to the rules and law. These are just a few questions that we'll be examining during the course of this hearing. I know many of you have traveled great distances to be here today to observe and to participate in today's hearings. I would like to take this opportunity to thank you all. Your participation and input on the disciplinary process will help the committee determine what, if any, measures are needed to improve or repair the system so that the members of the public as well as the lawyers and judges are all treated fairly and equitable by the disciplinary system. This hearing has generated a great deal of interest from the public. A lot of people want to speak today, but unfortunately the committee was not able to accommodate them all due to the limited time we have to hear. We have about 30 witnesses, close to 30 witnesses. And I'm going to try to ask everybody to keep their comments within 5 minutes. We want to get to the point so we can have the interchange between questions and answers. And due to the number of responses we received, the committee will conduct additional hearings in New York City as well as in Western New York so that we can get a better understanding of the total picture across the state and accommodate those who couldn't testify today. As I indicated, we have about 30 individuals going to testify, and I do apologize for that, but we're going to try to be as swift as possible. As I said, this hearing will examine the disciplinary process for the judges and attorneys in the state of New York. Judges in our state are disciplined by the Commission on Judicial Conduct. The Commission acts pursuant to Article 6, Section 22 of the New York State Constitution. This law was put in place in 1978 after the people of New York spoke with one voice that there needed to be a better system for judicial discipline. The legislature acted through the Judiciary law to codify what the people asked for, and that's in Article 2 of the Judiciary law sets out the powers and duties of the Commission. The Commission consists of 11 individuals, 4 appointed by the Governor, 1 by the temporary President of the Senate, 1 by the Minority Leader of the Senate, 1 by the Speaker of the Assembly, 1 by the Minority Leader of the Assembly, and 3 by the Chief Judge of the Court of Appeals. This commission is empowered to censure, admonish, or remove judges from office if necessary. They can subpoena witnesses, compel courts to release records to them, offer immunity to witnesses, investigate written complaints about judges, or on their own initiative conduct investigations concerning judges of the United Court system. There are approximately 3,500 judges and justices in the New York State's United Codified system. Last year alone, there were about 1,900 complaints of judicial misconduct, and of these, the Commission conducted 262 full-fledged investigations, along with 174 investigations that were pending from 2007. Dealing with the attorney discipline in New York is governed by the Appellate Division of the State of New York, Supreme Court. The rules that govern attorney conduct and discipline are found in rules of professional conduct. Lawyers who violate those rules are subject to discipline. This discipline can take the form of a letter of caution, an order of public censure, suspension, or disbarment of the attorneys. Only complaints that do result in formal disciplinary action, censure, suspension, or disbarment are available to the public. Once again, ladies and gentlemen, I want to thank you very much for being here today. We're going to try to conduct this hearing as quickly as possible in an orderly fashion. And I would like to introduce one of my colleagues who just came, Senator Perkins from New York City, from Harlem. But at this point in time, I would like my colleague, Senator DeFrancisco, to say a few words.
My words are very few. Everybody is handing in a written presentation. do me a favor, because I've gone through many, many hearings in the last 17 years, assume, just for the sake of argument, that we can read. You know, maybe that's maybe a bad assumption on behalf of officials of state government, but let's assume that we can read and get to the main points of your presentation. Otherwise, we'll never get you to say what's really on your mind, and we get into a reading contest, which doesn't do anybody any good. And those who are here and towards the end of the list will be here about 4 o'clock this afternoon waiting for their term. So please do that, and it will really be helpful for all of us. Thank you.
Senator Bill Perkins.
I'm going to be even briefer. I of course, echo the sentiments of my colleague in terms of the fact that the testimony has been written in the brief summarization that allows us to sort of explore your questions and your concerns more would be helpful. And I just also want to compliment the chairman for his vision with respect to this committee, and particularly on this issue, which is of such great importance to so many of us. And I would just want to urge him to keep up the good work.
Thank you very much, Senator Perkins. Without no further ado, we're going to get started. The first witness is Martin Gold, member of the Departmental Disciplinary Committee, First Department, and also Alan Friedberg, Chief Counsel, First Department, Departmental Disciplinary Committee. Welcome, gentlemen.
Good morning.
Good morning.
Good morning. Thank you. Mr. Chairman, distinguished members of the committee, my name is Martin R. Gold. I am a lawyer in New York City and a partner in Sonnenschein, Nath, and Rosenthal, a large law firm, a national law firm. I'm a volunteer member of the Departmental Disciplinary Committee for the First Judicial Department, appointed by the Appellate Division. I am also a senior member of the Policy Committee of the Disciplinary Committee. The chairman of the committee, Mr. Roy Reardon, very much wanted to be here today and to attend this hearing and participate, but another commitment made that impossible, and he asked me to attend in his place, and it's my pleasure to do so. With me is our Chief Counsel, Alan Friedberg. Together we will provide you with a description of the operation of the attorney disciplinary system in the First Department and answer any questions you may have concerning our operation. The Departmental Disciplinary Committee was established by the Appellate Division, First Department, to assist in the court's role in disciplining attorneys in the First Department, which consists of New York and Bronx counties. Members of the committee are all appointed by the Appellate Division, and they're all volunteers. There are approximately 80,000 attorneys in the First Department. As I've indicated, Mr. Reardon is chairman of the committee. The committee also receives hands-on guidance from the Policy Committee, appointed by the Appellate Division, from the members of the committee. The Policy Committee oversees the general functioning of the committee and the staff, and also provides direction on pending issues. Now, the Appellate Division has adopted public rules and procedures governing the Departmental Disciplinary Committee and rules governing the conduct of attorneys. These rules are available to the public, together with the rules of professional conduct, which govern attorney conduct, on the Departmental Disciplinary Committee website, which is part of the Appellate Division website. Also available on the website is information about the committee, including information concerning how a complaint can be filed. Information about filing a complaint is also available to members of the public who call or visit the committee's offices. Complaint forms are available in English, Spanish, and Chinese. It is important to note that the purpose of attorney discipline is not to mediate disputes between attorneys and clients or to vindicate the rights of complainants. Such matters can best be handled by the court system. Generally, fee disputes, issues of legal strategy, and single incidents of malpractice that might be addressed in a civil matter do not constitute misconduct. The Appellate Division and the committee must devote its limited resources to the limited remedial options within its jurisdiction. Pursuant to Section 90, Subdivision 10, as Senator Sampson mentioned, of the Judiciary law, all materials concerning an investigation or proceeding concerning an attorney's conduct are sealed until the Appellate Division issues a decision sustaining charges of misconduct concerning an attorney. When the Appellate Division issues such a decision, the record of all of the proceedings becomes public. The Office of the Chief Counsel for the Disciplinary Committee is staffed by 23 attorneys. The staff attorneys screen complaints, investigate allegations of misconduct, and prosecute cases at hearings. As I have indicated, Mr. Alan Friedberg is the Chief Counsel. Here's the process by which a complaint is handled. When a complaint is received at the committee, it is immediately assigned to a staff attorney to be screened. Investigations may also be commenced by the Chief Counsel on his own initiative, even in the absence of a complaint from a third party. Since numerous attorneys have offices in more than one location in the state, the address that an attorney lists in registering with the Office of Court Administration determines which disciplinary body exercises jurisdiction over that attorney. Complaints against an attorney who is registered at an address in another judicial department are referred to the appropriate disciplinary body. Accordingly, each regional disciplinary agency is able to keep a record of all complaints filed against that attorney. Complaints against judges are referred to the Commission on Judicial Conduct. We have no jurisdiction over them. The staff attorney who screens the complaint reviews the entire complaint, including attachments, and may choose to interview the complainant, obtain court documents, or obtain documents or information from the attorney who is the subject of the complaint. If the staff attorney believes the allegations are likely to warrant formal charges, he or she refers the matter to the Chief Counsel for immediate assignment. If the Chief Counsel concurs that the allegations are likely to warrant formal charges, the complaint is immediately assigned to a staff attorney for investigation, which may include obtaining a written response from the respondent attorney, scheduling testimony of the respondent attorney or others, and obtaining records, including court records and bank records. And we have subpoena power to do that. In cases where there is conclusive evidence of serious misconduct or failure to cooperate with the committee is authorized to make an immediate motion to seek an attorney's interim suspension during the proceedings. If the allegations appear less serious, the screening attorney may determine to seek the written response of the respondent attorney. When that is obtained, it's sent to the complainant, who's requested to reply to the attorney's response. After obtaining this information, the screening staff attorney may recommend in writing dismissal or assignment of the matter to a staff attorney for further investigation. Each recommendation is reviewed by the Chief Counsel, who may determine to assign the matter to a staff attorney for investigation or recommend dismissal of the complaint. If the recommendation of the Chief Counsel is to dismiss the complaint, the Chief Counsel signs the recommendation memorandum, and the entire file, including the memorandum, is sent to one of the 55 members of the Departmental Disciplinary Committee who must approve the dismissal. If the complainant seeks reconsideration, the matter is sent to another attorney committee member who must also approve dismissal. And if there's disagreement, we have procedures to deal with that. The committee members are appointed by the Appellate Division and include experienced practicing attorneys, former prosecutors, and approximately one-third are lay members.
So this committee that reviews it, they are appointed by members of the disciplinary?
These are the members of the committee, of the disciplinary committee, all of whom are appointed by the court.
Okay.
Mm-hmm. Okay. The types of complaints that are dismissed include those complaints expressing general dissatisfaction with the outcome of a case without an allegation of specific misconduct by an attorney, a very common kind of complaint. There's a losing side in every litigation.
We know that. And Ms. Gold, we're just trying to keep everything within 5 minutes because we have quite a few members. So,
well, I'm going to the heart of what you're asking about.
Okay, you can. That'd be great.
Is how these things are reviewed internally and what are our procedures. The committee has discretion to refer action concerning possible misconduct by an attorney until litigation in the court system is concluded.